Hi, this is OC estate plan lawyer Michael Pevney, and today I'm going to be talking about, for some people, why it might be better to have a will instead of a living trust as the central estate planning document. For people that have kids or who own a home in California, it is usually going to be better to have a revocable living trust as that estate planning document. The reasons being, first, sheer cost. A will has to go through probate almost all the time, and that can be a very expensive process. Control. You want to have control over those assets, when and how they're distributed. A trust gives you much more control over that. Privacy. Probate is a public process, and when a will goes through probate, there's a lot that's open to the public. When a will goes through probate, that is a public process that the public has access to. Whoever wants to see what the terms of a will are, they get to see that. And the fourth reason, of course, is time and hassle. Oftentimes 12 to 18 months before any beneficiaries of a will can get any property distributed to them. But there are certain people where a will might be a little bit better for them than a trust. A will is typically less expensive than a trust to create a trust. And if somebody does not have kids that they're going to use as beneficiaries and does not own a home, there is a process in California where if your estate, the value of your estate is under a certain level, it was passed a few years ago, that amount was set at $150,000, and that was tied to inflation, and it's gone a little bit up over the years. Right now it's $166,250, so if your estate is less in value than that, your executor or somebody can file an affidavit in court so that estate does not have to go through probate, and that estate does not have to incur any of those fees. So probate does not become expensive. Now, in that situation, you do lose all the control over as much control as you want, as opposed to a revocable living trust. But creating a will can be much simpler. Anybody that's over the age of 18 should have a very basic, at least a very basic estate plan in place. Now, let's remember that a will is not the only part of an estate plan. In addition to a will, somebody where a will might be preferable should also have several other documents in place. And those would include a durable financial power of attorney, so someone can take care of any financial issues when they are incapacitated or injured or in a coma. Additionally, they should have a healthcare power of attorney, so somebody can make decisions for them if they become incapacitated. Of course, also included with that in healthcare documents would be an advanced directive. So your voice is in the room even when you can't be heard to make those decisions. So medical professionals know what your desires are beforehand, before any sort of coma or incapacity or inability to care for yourself. So always those financial and healthcare documents are part of any estate plan, and if somebody is probably on the younger side, doesn't have a huge amount of assets, does not own a home in California, and does not have any children, a will can be a preferable document to a trust, oftentimes because it is less expensive to create. Thank you for watching. This is OC estate plan lawyer Michael Pevney. I can be reached at 949-377-2996 and found at ocestateplanlawyer.com. Thank you for watching.